Hi everybody, 6 o'clock, we're bang on time. Welcome to our latest live newsletter for clients of Brody Jackson Cantor. And this evening's live newsletter is basically on the launch of the public inquiry into the COVID-19 pandemic. So our aim on this, as in previous live webinars, has been and is to help you, our clients and members of the COVID-19 Families for Justice group, basically to get to grips with where they stand in the ongoing legal process. And tonight's webinar is basically for our panel to brief you on recent progress and to answer your questions now the launch date for the inquiry has been announced. It normally lasts just under 60 minutes. I try to make sure these things don't go on for longer than an hour, so we keep it nice and pithy. The running order for this evening, we're going to start with Elkin, just doing a few introductions, because we've got a new member of the panel who's just joined us and who you're going to become familiar with, certainly if you're a client of ours. And our panel tonight, Elkin, Nicola and Pete, will then offer some updates on and their insights really into development since our last webinar, which was, crikey, at least a couple of 3 weeks ago, I think. So we'll then move on to answer any questions that have already been submitted before, and I think we've only got a couple of those actually, before finishing off by answering any questions on areas that we haven't already covered. So over the next hour or so, basically, you guys are going to be brought bang up to date with the current state of affairs. Now, just before I move on, I just want to introduce the live newsletter format because we've got both Brody Jackson Cantor clients and COVID-19 Families for Justice group members on this webinar who may not have attended previous live newsletter sessions. So I just want to explain that the team at Brody Jackson Cantor are already sending clients who've asked us to represent them regular email updates. And this session is simply a kind of live version of that, a live newsletter that's run in a format that's designed to allow your legal team to update you directly on what's happening and for you to ask them questions. However, as the launch date for the inquiry gets closer, if there are any more members of the COVID-19 Families for Justice group who would like to be represented at the inquiry, then towards the end of the session, I am going to give you details of how you can instruct us if you've not already done so. Before I go to Elkin for the introductions, a really quick word on asking questions and making comments tonight for anyone who's not been on these things before. So number one, questions. As I said, after our panel's update, we're going to start off by answering a few of your questions that have already been submitted. If you've got any questions as we go along on anything you hear tonight, then please do write them in the Q&A section. I'm just looking, Q&A section, which should be in the foot of your webinar screen in that navigation on the screen. If you can put your questions in the Q&A, that's really useful. If you put them in the chat, it's not the end of the world. Chris will try and swap them over to the Q&A, but it's the Q&A that Chris, our moderator, and I are looking at all the time to try and pull those questions out. As per usual, all of the questions and answers to this session will be published on the Brody Jackson Cantor website. And I'm just going to ask Chris now. Chris, can you just drop a link to the section of that site into the chat now? Just so people, it's a really useful reference for anyone who's not been on the previous webinars, and I think this is probably our 5th or 6th. All of the questions that have ever been asked are grouped there under categories, so it's quite easy to find the answers to a lot of things if you miss them today. And then just to reassure you, any questions that are asked today are anonymized before we ask them or before we post anything on the site. So please don't be shy about making a query. All of those questions are anonymized. And then finally, just quick word on comments. So last time we had a few comments on some of the opinions that were voiced in the chat over previous webinars. So I just wanted to say once again that the chat, we believe, is an important reflection of the views of the broad range of people that we have on these calls and within our groups. We don't moderate the chat. We believe that everyone's opinion should be heard in full. And whilst details may differ, all I think we're asking you is that we're pretty much all after the same things. So please do respect that thought as you participate in the chat. Be most grateful. Thank you very much. So enough of me. I'm now going to ask Elkin. Elkin, can you just introduce the panel for tonight's session, please?
Yeah, firstly, there's Pete Weatherby, QC, who's head of the council team, and who anyone who's been to any of the previous sessions will already know. Secondly, there's Nicola Brook, who's recently joined the COVID inquiry team from our own department. She's been working on the Manchester Arena inquiry and has worked on other major inquiries before then. So she's well experienced in this type of work. And she will be having a lot of client contact going forward. So again, you'll get to know her. And thirdly, of course, there's me, nominal head of the major inquiries team. Nicola and I will be co-running the inquiry process, certainly for the foreseeable future.
Not sure there's anything normal about you, Elkin, but anyway. Okay, thanks very much. So just one more word then on confidentiality before we quick off. So quick reminder, everyone on today's webinar is bound, or certainly on the panel is bound by the same duty of confidentiality. Nothing goes outside this webinar. Any questions raised in the Q&A on your webinar screen will be answered directly in the days following this session. So you'll get your own personal answer to that. And all questions that are asked are anonymous and anonymized, and no personal details will be shared. The attendees on today's webinar are either all clients of Brody Jackson Cancer, members of the COVID-19 Families for Justice group. There's no one from any other groups on there. And the webinar will be recorded and edited if necessary to ensure that it doesn't include any of those personal details. And the recording will then be sent to clients. So there we go. Don't be shy is the bottom line. Do ask your questions as we go in, and I can see one or two already appearing on there, which is great. Let's kick off with session one, and I'm actually going to start, if I can, with Nicola. Nicola, I know you're going to play a big part, and clients are going to get to know you quite well as we get close to the inquiry and as the inquiry goes on. Can you just give people an idea of what your role is and how that's going to benefit them, how you're going to be communicating with them and things like that before I come back to Pete and ask him to give us an update on the legal part?
No problem. Good evening, everyone. I have been working with the firm since 2013. I joined to work on the Hillsborough inquests. I then, alongside Elkin, ran the Birmingham pub bombings inquest before moving on to the Manchester Arena inquiry. So I have been involved with COVID for a few months now, but I've mainly been working backstage, so to speak, just making sure that we are able to have the office logistics set up so that everyone who wants to have a file open with us is able to have their matters progressed with us. So some of you will have already had contact with via email or phone. I have attended a few of the meetings. I attended one of the consultation meetings in Liverpool. I've attended meetings with the group and also some of the meetings with the inquiry legal team. So I'm well up to date with where everything is. Going forwards, I'll be helping to lead the team in terms of all the client interactions. So if anyone has any more detailed questions, if one of the team isn't able to answer those, they'll come to me. And I'll also be liaising with the inquiry legal team going forwards. And we will then be moving on to the disclosure side, which is when we'll start to direct the team to liaise with you about what issues are most important to you and how we can filter that evidence through to you so that you are kept as up to speed on everything as we are.
Brilliant. Okay, so essentially, you and your team are the first point of contact with all the clients that have instructed us, yeah?
Absolutely, yes.
Brilliant. Okay, fantastic. Will you be sharing? You presumably have already shared your details with all of those instructed clients, or you will be doing in the run up to the launch, yeah?
Yeah, all my details are on the website. We also all have access to a joint email address that we can all, everyone in our team can see. Whenever I respond from my personal email address, so people can contact me directly if they want to.
Brilliant. Okay, thanks very much. So if anyone's got any questions there for Nicola, you can stick those into the Q&As as well, or what have you, and you will have her details. So thank you very much for that, Nicola. Right, Pete, can I bring you in now, please? I think you've got 3 or 4 things that you're going to talk through. I think you were going to start off with the situation with our current Prime Minister and how that might affect us. So are you okay to start, Pete?
Yep, absolutely. Hello, everybody. I prefer to term him our outgoing Prime Minister. He's obviously resigned, as we all know. We've had quite a number of people say, well, will that make a difference? Well, first of all, it won't make any difference to whether he's called as a witness, and of course we hope he will, or any difference to what he has to disclose to the inquiry, and we'll be pursuing that with vigour. Does it make any difference to the progress of the inquiry? Well, happily, not much. If just to recap, if you recall, he declined to have an inquiry when we were threatening to judicially review the government for not having an inquiry. He then decided that he would have an inquiry and then delayed announcing one for a very long period of time. So 2 years were wasted effectively by that before he got round to appointing a chair last December, Lady Hallett. And then after that, he's further delayed the process by not certifying a setting up date. Now, this all sounds very technical, and it is. A setting up date is rather a formal requirement, and it's kind of like a starting gun. It doesn't mean an awful lot more than that. But unless the minister, in this case Johnson, certifies a setting up date, then the inquiry can't look at any evidence, and this inquiry has construed that as stopping them even gathering evidence. So that has been a problem. Eventually, not very long ago, you'll recall that we threatened to judicially review him, I think for the 3rd time, on the basis of unreasonable delay. And then happily, he gave in again and certified a setting up date, which was the 28th of June, and at the same time finalised the terms of reference, which we're relatively okay with. All of this sounds like a formality, and it is, but it is in fact quite a significant one. It's a significant moment because once the minister certifies the setting up date, then control of the process, i.e. the ability to delay it, passes from the minister to Lady Hallett. And so that's a significant moment of itself, but very much more significant when we then have his resignation only really a few days later. And had he not signed off the terms of reference and the setting up date, who knows what would have happened. And I can only suggest and suspect that there would have been even more delay with the excuse of the current leadership election. So that is, although very, very late indeed, 2 years plus late, it is good news, and the inquiry is off and running. So any delays from here on are not to do with Johnson, but they will be with the inquiry themselves. The only hangover from Johnson's resignation is that he has indicated that he's going to appoint 2 panel members, and he hasn't done so yet. And we're not at all sure whether he is going to nominate them now that he's resigned. This isn't the biggest deal. We have asked him not to, so that the new Prime Minister will do so. It won't delay things. There's no particular problem with that, but we think it's probably better if it's not Johnson, it's somebody else that nominates further or nominates panel members. Second issue I want to address is just the progress of what we've been doing, and we've been trying to engage with Lady Hallett's legal team, and I have to be completely upfront with you, it's not going quite as well as we would like. Last week on, I think it was Thursday, the legal team plus the 3 devolved legal teams, and of course we're all in one broader team working together, but the UK team and the 3 devolved teams had a meeting with the inquiry legal team, and that included their lead solicitor and their lead QC. These are supposed to be a means of discussion and dialogue and collaboration where we can all work together to achieve some progress. And this was the second of this type of meeting. It's good that we're having the meetings, but it's right also to say that both of them have been very disappointing. the meetings really have been us raising all of the issues that you know about from the correspondence we've had with you, and the documents that we've circulated to you, the submissions we've made to Lady Hallett in writing, things like pen portraits and how your evidence is going to be heard about the circumstances of the passing of your loved ones, and indeed your own experiences. Matters such as the timetable, how they're going to deal with the various issues, whether they're going to deal with modules, and how hearings are going to occur around the UK. So all of these process matters we're trying to push forward, and we're trying to collaborate and work with Lady Hallett's team. But regrettably, we're kind of being met with a polite but minimalist approach, where we're not really being given any information, or we're being answered with vague assertions that Lady Hallett will be looking at those issues, which is all rather disappointing. They say they're working hard, but they're not telling us what at, and there's no real dialogue going on about any of these issues, which is what's needed. I promise to be transparent with you. I'm not trying to be glass half empty here, but it is right to observe that in various other inquiries your legal team, various members of your legal team have been involved in. By this point, we have been further down the track in terms of collaborating with the inquiry. And so you will see that I am a little bit frustrated by this. We will press on and we will achieve our aim, hopefully, as soon as possible. The one thing that we have learned today is that Lady Hallett is going to make what is being termed an opening statement on a week tomorrow, on the 21st, Thursday the 21st. She's going to do that not at a hearing, which is the usual way of doing it, where of course there can be interaction and we can make submissions and there can be dialogue in front of you in public. But she's going to do it simply by an online opening statement, as I say, next Thursday. And we don't know anything more about it because they simply haven't told us. In fact, they simply haven't told the legal team at all, and we've learned that from an email that was sent to, I think, to the campaign, telling them, and that of itself is disappointing. It doesn't really make any difference, but the proper way of lawyers representing the chair and us representing you is that we talk to each other, and they should have informed us, and they didn't. As I say, it really doesn't matter, but it is kind of indicative and disappointing that Lady Hallett and her team aren't really engaging in the way they ought to with us. Third topic I just want to raise is a number of people have asked what we need from you, what interaction we need from you. Well, we need your questions, anything that you're concerned about, anything that we've failed to make clear to you. Just write in, you can put it in the chat now, or you can send us an email and we will get back to you about any concerns you have. But more than that, we're compiling a short questionnaire really, so that we can just gauge what the main themes that you want us to concentrate on in the main areas. We think we know what they are, but we don't want to go forward with our views. We represent you, and it's your views that matter. So we'll be sending out a questionnaire. It'll be purely to help us to do our best for you. That'll be going out as soon as we get some headspace to do it. And then once we get some clarity about pen portraits and your evidence, then we will be contacting you about that. And can I just reassure everybody that this will be a voluntary process. Nobody has to engage with pen portraits or evidence at all. But I know that many of you want to. And so we will facilitate that. But again, we have made quite detailed submissions, which you have seen because they've been circulated to Lady Hallett, but we haven't had any feedback about those. We understand she may be saying something about this next Thursday. She's terming it the listening exercise. So hopefully we'll learn a bit more. I have to say that I'm slightly concerned because I would have hoped that they would have had some discussion with us. So I fear that that Lady Hallett's view might be not quite what we want, but we don't know until we hear. So let's wait and see. Okay, the next topic is that today, again, all very topical today, but today there's been a news feed in is it Bloomberg that about disclosure and the fact that the government have consulted or asked for advice from their most senior legal advisor, Sir James Eadie. The issue of disclosure is key, and it's one of the things that we're moving on to now. And we're very anxious to discuss it with the inquiry team. We've tried to do it. It's to do with evidence gathering. Without gathering all relevant evidence, the inquiry will not be able to do its job. Obviously, there'll be a vast amount of material, and therefore, in this particular inquiry, there needs to be a smart approach to that. So we need some engagement about that. And we've got some, we hope, pretty smart suggestions to make to the inquiry about how to approach disclosure. But this discrete issue that's arisen today is about what the government might not disclose. And this is somewhat troubling, but it may be something and nothing. So I just want to kind of lance the boil and reassure everybody that we are going to deal with it. Sir James Eadie is somebody who's well known to us. He's the QC that the government turns to in the most serious and complex matters. He dealt with the Brexit cases in the Supreme Court for them. He's dealt with many of the security services arguments in the Manchester arena and various other things. But he's been asked, according to the media reports, to advise the government about what they don't need to disclose or what they can withhold from the inquiry. And the media reports say that he's advised them about cabinet privilege, basically. And also the media reports suggest that he's advised the government that they may face many expensive civil claims arising from the response or the lack of response to the pandemic. Now, let me stress first of all that we just don't know how true this story is or what's behind it. And there might be a bit of a mix here. There might be some of this might be accurate and some of it might be a little bit beyond that, but we don't know and we'll ask. There is nothing wrong with the government seeking legal advice. And the focus from anyone and everyone who wants the inquiry to succeed, and that should include government, must be maximum candor, maximum transparency, maximum disclosure. And therefore it would be troubling if the government were seeking legal advice about what they could get away with not disclosing. And therefore already today the campaign has written to government raising concerns about this and written to each of the leadership Conservative candidates asking them to pledge maximum openness. And you can all rest assured we'll be pushing that line long and hard. Legally, all organisations, including the government, all organisations and individuals with potentially relevant material should produce it to the inquiry, subject only to very narrow exceptions. And those exceptions might be things like national security, which is unlikely to arise here. Another exception is legal professional privilege, which is a privilege which protects communications between lawyers and clients generally. I'll come back to that in a minute. And there are these issues that appear to have been raised today regarding cabinet privilege, which is basically a privilege which protects cabinet members from disclosure of discussions that they have. And the point about privilege is that without having protection of those types of discussion between lawyers and clients, then you can't get the level of frankness that is required to reach the right answer. There's nothing wrong with the concept of privilege, but I have to say that sometimes it's overused. Now, you've all heard us going on about this duty of candour idea, and this is where the duty of candour really kicks in and where it's important. And we will be arguing, as some of us have in other inquiries, including Grenfell and the Manchester Arena, that the chair should pursue position statements from government departments and public servants and organisations. And position statements are documents where the chief officer or the head honcho, whatever we're talking about, is required to proactively set out that organisation's understanding of what happened, but also what went wrong. And that's the important point, and to identify all relevant material. And so before we get into the problems that might arise from these arguments about privilege, we want to go back to the basics and try to require everybody to be proactive in providing material in the first place. And then before we get near to any kind of argument about these potential exceptions, we will write to the government and we will ask them to waive any privilege. So we won't agree that the privilege attaches to anything at all, but we'll say if it does, can we just avoid any delay or any arguments about it? Will you waive privilege? And there are a number of previous examples, particularly with the legal privilege, where organisations, public authority organisations usually, have agreed to waive legal professional privilege. So there's plenty of authority on precedent for them to do so. So we will try to do that. And it'll be quite embarrassing for them, I think, if they don't waive it. And then we will take that idea forward and we'll ask them to waive any other privilege that attaches. If they indicate that they won't, then of course that will be in the public domain. And so everybody will know about that, and the media will be able to pursue that. And then we will argue it in front of Lady Hallett, and we'll argue for the narrowest possible application for any such privilege that arises. So I hope that makes the position relatively clear. They are very important issues, and what we must avoid is any suggestion that the government or Johnson can determine what material is disclosed to the inquiry, because that would be very toxic indeed and would defeat the object of an independent inquiry. However, let's not get ahead of ourselves. As I say, let's work through the nuts and bolts of disclosure and then take each of these issues head on. But we're on notice and we're on it. So I hope that that's not going to create too much of a problem. Finally, before I hand over to someone else, just on a completely different topic, we've been working closely with the Northern Ireland team and the Northern Ireland families. And last week we had two very fruitful meetings indeed, I think, with the two main parties, Sinn Féin and the DUP, with the aim of persuading them to back a Northern Ireland devolved inquiry in the way that Scotland has already instituted such a devolved inquiry. There's been a positive response from one of them, a very positive response from one of them, and the other one was very positive, but they wanted to have further internal discussions. So we're waiting for them to get back to us formally. But it is quite encouraging, really. And then there's a further meeting with the Alliance Party, with the third main bloc. And so when we have responses, formal responses from all of them, we'll be in a good position to move forward. So all we can say at the moment is that the possibility of a devolved Northern Ireland inquiry is more likely this week than it seemed the week before last, but we'll see. And the fact that the Northern Ireland Assembly being suspended still at the moment is something of a problem, even if all of the main players are positive. But it is a positive work in progress, if I can put it that way. So that's really just a roundup of what's been going on since the last webinar, as far as we're concerned, and I hope answering some of the concerns that have been raised. So can I hand back, Andrew?
Yeah, thanks very much. That's great. I've just got a couple of follow-ups on that, actually. So on the Boris Johnson bit, will Johnson remain the minister responsible for the inquiry as he appointed himself to be? If not, will the new Prime Minister appoint a replacement?
I think, oh, that's a good question. I think technically that it's the Prime Minister rather than Johnson personally who will be the minister, but the better answer really is it doesn't really matter. That now the setting up date has been established and the terms of reference finalised. Control has passed to Lady Hallett, so I don't think that's something we need to worry too much about.
Okay.
I suppose, sorry to interrupt, I suppose it matters as far as the appointment of the panelists is concerned.
Yeah.
Because that remains in the power of, I'd say, the Prime Minister, not Johnson as a person. The role of the Prime Minister has that power.
I think you're absolutely right. So Johnson, I think, could appoint the panel members before he goes, but whether he does or not, the new minister responsible can appoint further panel members anyway, or remove them. So yeah, but you're right, yeah.
Okay, so we've got a couple of sort of big themes cropping up at the moment. I know you've just talked about pen portraits, Pete, but we've had a load of questions coming in. So because I was reading the questions, I just want to check we've covered this because we've got a whole bunch of these. So let me just ask a number of them. Hi team, do you know yet when you will need statements, pen portraits for the listening project? Also, do you have a template we can use to get started? You might have answered that already. Can you explain more about what pen portraits are and how they might be acquired? What are pen portraits? I missed earlier meetings, so I'm not aware of this. If I've agreed to write a pen portrait, when will I be contacted? So Elkin, Pete, can you just go into a bit more detail, 5 minutes, just about pen portraits, because we've got a whole set of questions on that.
Yeah, first of all, we produced a written advice for people, and then we agreed with the families a written submission which went into the inquiry. So if anyone has missed those, if they email Elkin or Nicola, then they will be provided with those and they can read those. But basically a pen portrait is a statement by a family member or a video by a family member as to their loved one's life. So not the circumstances of their death, but what they were in life. So it brings the process into the real world, if you like. We're not talking about names, we're talking about real people, and it memorializes your lost loved ones. Now, there are various ways that can be done, and we put those forward to Lady Hallett, but we haven't had a response. So we just don't know at the moment. We hope to know a bit more next Thursday, as I say. But first of all, can I just repeat what I said earlier, that pen portraits, or the production of pen portraits is very personal and it is voluntary. So you don't have to do, even if Lady Hallett agrees with everything we've said, and that we don't assume she will, but even if she does, they will be voluntary. So you don't have to do one, but if you want to do one, then we will happily discuss with you how to do it. Now, some people have already indicated that they don't really want any help. They'd like to do it on their own, and that is entirely fine. Within reason, you can put anything you like in a pen portrait, and they often just set out a narrative of your lost loved one's life and any achievements you want to highlight, or any happy circumstances, or just life circumstances that you want to put into a memorial. And traditionally they are then played or read out in the hearings. But of course here, with the colossal loss of life, then there is obviously a discussion to be had about how that they would be incorporated into the inquiry. And we made a number of proposals about how that would be done. So we don't know what Lady Hallett's view is, and therefore we're not in a position to pursue it. But as soon as we do, then we will be offering assistance to anybody that wants it. And we're very happy to make suggestions, but ultimately it really is very personal and down to individuals. And as I say, they can be simply statements, or they can be videos, they can be a compilation of different family members, or indeed, I've seen statements from teachers at schools or work colleagues and things like that. Nicola or Elcom, is there anything else?
I was going to say, Nicola, do you have anything else on pen portraits?
Just really to say that I know some people view it as an invasion of privacy, and that's completely fine. Our view has always been, if people want to do it, we're there to help if you want us on hand. And really, we feel it's more important in this case than perhaps any other, simply because your loved one shouldn't just be a number. They had a name, they had hopes, they had dreams, they had things they wanted to achieve. They might have had a funny laugh, they might have made the best roast potatoes, all those things that are so personal to you that you want people to know about. Those are the kind of things that will mean so much and will make your loved one a real person. And believe me when I say that in a room full of lawyers who are listening to evidence all day, hearing about real people and what they could have done if they'd had more time, it really does strike a chord, particularly with the chair and also with the media. And that really is the power of a pen portrait if you are wanting to do that.
That's a really nice way of bringing that to life, actually. Thank you, Nicola. That's really cool. Okay, Elkan, anything else on pen portraits before I move on to the next big one?
There's a question just popped up. How long should it be? And the answer is as long as you feel is appropriate. There's no rule about it. It doesn't have to be a text. It can be a video. It can be a song, a poem, a combination of whatever you feel is appropriate, really.
Okay. Just to remind everybody that all your individual questions and answers will be answered directly. So if we don't, there's some very specific ones on here, and there's a lot coming in, a lot more than we normally get. So Chris and I are struggling to keep up with all of it. We're getting the big themes out here. So just to reassure you, you will get personal answers to all your questions. So for those of you that are asking for details, personal details of our team and stuff like that, all of that will be sent through to you. Let me go on to the next sort of big theme then, and that was NHS and hospital-acquired COVID. So we've had a whole load of questions coming through on that, guys. I'm going to read 3 of them to you, and then if I can ask Elkan to hand them around the team. So the questions we've had were, well, amongst the questions we've had, I was wondering whether the inquiry will also be able to address how individual hospital trusts coped with trying to prevent hospital-acquired infections, and importantly, how they could be held to account. Number 2, will the NHS be held accountable or investigated? There are cases where there was negligence against COVID patients. I would like to understand how much will hospital-acquired COVID be covered? And there's been a good, I think, probably 10% of the questions have been about hospital-acquired COVID and whether that will be covered in the inquiry.
Yeah, absolutely. It's the answer to that. Hospital-acquired COVID will be published, will be covered. The question about individual trusts, I think, raises a general issue as between the individual and the general, not just for trust, but for all sorts of issues that are arising. And it's important that you're all aware that the inquiry will only look at individual issues where it feels that those issues are relevant to general themes. And I know that sounds a bit abstract, but it's probably easily explained in the context of individual trusts. I don't know how many individual NHS trusts there are in the country, it must be about 80, but I can guarantee that the inquiry will not want to hear evidence about every single individual trust. But if there is a general theme emerging, for instance, of the do not resuscitate process being mixed up into an end of life process, she will, I hope, hear individual evidence about a number of trusts where that has happened, which will inform her as to the general picture. We're predicting here, we can't be sure how she'll respond, but it's all about the general and the particular and how one informs the other. So not a lot of individual or particular evidence, or the emphasis is always on themes and general issues. And that's mainly because of manageability. It's just not possible to do it in any other way. There was a mention of negligence. I don't know, Nicola, if you want to make a point about negligence.
In general terms, the inquiry will not be appointing any kind of specific blame that raises issues of criminal liability. Where we're talking about medical negligence, I think they would want that to be pursued through civil litigation. They won't make findings of fault about specific deaths, and they won't have the resources to investigate specific deaths, unfortunately. And that's where Elkin's point about the more general issues that would relate to a specific issue on that ward, for instance, that's what they would be more looking at, and whether that was informed by a government policy, if that makes sense.
Okay.
Yeah, can I just take that a little bit further? That there have been and there can be more inquests where if there are individual cases where there have been individual fault, then an inquest might well be opened or reopened to deal with that matter. So in the broad terms, as Elkin and Nick have said, that the policy in the general terms are dealt with better in a public inquiry, but where there are specific individual failures like that, the inquest process is the more likely avenue. Now, that's not easy for a variety of reasons that I won't go into for time reasons, but there have already been quite a number of inquests, and there can be further inquests as well. And just in terms of the individual hospital trusts point, I think that there will be examples of individual trusts, but I don't think it's credible as not practical as Elkin says to think that the inquiry will deal with all 80 hospital trusts and all of the care home providers and things like that. And therefore that's where the dialogue that we keep trying to establish with the inquiry team is, to get the happy medium, if you like, where we can get quite a bit of evidence of using individual hospital trusts to show a general deficit. So I think that's the important issue there. And an accountability, although it's absolutely right that an inquiry can't determine criminal liability or civil claims, it's also right that it can't be inhibited from making determinations just because someone might think those determinations implied a criminal or civil finding. And that's important. An inquiry does three things. It establishes the facts, it establishes accountability, and it makes recommendations to stop the same thing happening again in the future, to learn lessons. You can't learn lessons from the facts unless you have that middle bit, accountability, because accountability relies on finding failures and who is responsible for those failures.
Okay, thank you. I'm going to jump to another slightly different one. We had a couple of questions right back at the beginning, and it was one I was going to cover at the end, Elkin, but we're going to go. We've got so many questions. I've got a couple of other big topics to cover, and I just want to get this one in. So I had two questions from people. Number one, I've been asked if I have a legal representative. I wasn't sure if someone can represent me, as I'm not in a position to pay a lawyer to represent me. And number two, does the agreeing of the terms of reference and inquiry start mean that all legal fees will be paid by the government? So can we just cover that point we were going to do at the end in terms of free legal representation at the inquiry? And can you explain how people, if they're not already represented by us, so for instance, members of the COVID-19 Families for Justice group who'd like to be represented at the inquiry by Brodie Jackson Cantor, how can they instruct you if they've not already done so? And how much will they need to pay if they do instruct you? Can you answer that one for me, please, Alkan?
Yeah, the short answer on how much you need to pay is nothing. The inquiry will, at some point, cover all our costs. It's a bit of a sore point because we think they should have started paying our costs from when they were set up, but they seem to be dragging their feet, to say the least, on it. So at the moment, we're carrying on acting pro bono, that is without charge to anyone. But from your point of view, either we'll be acting for nothing or we'll be getting paid by the inquiry. As far as contacting is concerned, you can go onto our website and look at the legal representation page, and Chris is going to put in a link to it, hopefully.
Yeah, Chris, can you put that link onto the chat now? So for anybody who wants to be represented, we're just going to get Chris to put a link on the chat right now. Okay, thank you. You
can email us, and again, hopefully Chris will put the email on, but it's enquiry with an E at brodiejacksoncantor.co.uk, or our phone number, which is 0151 601 7405.
Brilliant. Okay.
So that should be fairly straightforward.
Thank you for that. And again, if there's any, if you've got any other follow-up questions to that, anyone, do just drop them in the Q&As. You will all get individual answers to all your questions. Okay, let's go on with ongoing issues and the scope, because I think we always at some point in these come to the scope and what will be in and what will be out. So a couple of things on the scope. Will the inquiry look into ongoing issues, i.e. vulnerable individuals not receiving their spring COVID booster in a timely fashion? We've had a lot of people talking about access to those boosters and what they've had. So will the inquiry look into ongoing issues, including vulnerable individuals not receiving their most recent boosters?
That's a tricky one, because at the moment the terms of reference have a closing date. The hope is that during the course of the inquiry we'll be able to raise events which are after that closing date. I think the closing date was the setting up date from memory. I don't know if that's right. Pete's nodding. So the chair could, if she wants, say, well, my terms of reference ended then, I'm not prepared to look at anything after that date. Depending on how significant events are after that date, and I suspect they will be significant, we could call for a separate inquiry, which would seem to be a bit silly if there's one going on at the moment. So, I mean, the hope is that the chair will see sense and ask for the terms of reference to be amended, but we can't really answer that at the moment, unless, Pete, you think there's something to add.
No, that's the point, is that terms of reference are not set in stone, and they can be amended. So if there's something that needs to be looked at after the setting up date, then we will ask Lady Hallett to ask the minister to amend the terms of reference to let us do it. And it would be pretty stupid not to. I mean, the idea of setting up yet another inquiry would be just daft, wouldn't it?
Okay. Let me ask a follow-up to that then. Do you think this inquiry would be able to look at structural racism in relation to COVID deaths? I understand that the terms of reference disincluded ethnicity, but there is a disproportionate level of vulnerability and death among BME people.
Yeah, this is something that has been a central discussion point all the way through, because the Prime Minister's original terms of reference virtually ignored this issue. And so we successfully argued that Lady Hallett should ask the Prime Minister to make it a prominent issue at the head of the terms of reference, and we've to a significant degree achieved that. The wording isn't what we wanted. We haven't achieved everything, but I think that well, so far as I'm concerned, the terms of reference allow for all such issues to be raised, and everyone can rest assured that they will be front and central in our thinking as we progress the case. Those are absolutely vital parts, and the inquiry will fail unless it does so.
Okay, thank you. Let me ask the third one of those. Do we know if the government will be interrogated for ignoring the pandemic planning exercises carried out in the recent years before COVID?
Oh, yes.
There was one that modelled a SARS-CoV type viral pandemic.
Yes. Again, this is something that we weren't happy with. I'm still not over the moon about the way the terms of reference have been left about this, but this falls into preparedness. We've argued all through that there are two halves to this inquiry. One half is what happened up until the pandemic started, preparedness, and what happened once the pandemic struck, response to it. And those are both absolutely key. And the failure to undertake proper exercising about pandemics, and the failure to heed the lessons of the few exercises that did apparently take place are a significant part of the preparedness aspect of this. We think the terms of reference are wide enough to make that clear enough within scope, although we did argue that it should be much more specific than that. But absolutely, I mean, again, it isn't, you can't just wait and examine what happened once the stable door was open. You've got to look at why it was open. And a pandemic was the #1 recognized threat to life in the UK from the very start of the National Risk Register. I mean, it was pandemic flu, but emerging diseases was also very high on the list. So there is absolutely no excuse for this country not being prepared and not having PPE and not having proper contingencies, rather than the make it up as you go along approach, which is what we ended up with.
Okay, thanks for that. I think I'm after a bit of reassurance for this next section, actually, because I've got a whole list of questions I've put under the heading sham question mark. Do we think that the lack of collaboration is down to the size of this inquiry and them still trying to formulate the way going forward? I get a sense they're still finding their feet on how best to move forward. Question number 2, is it understood why the chair has backed off, as she seemed really engaged beforehand? And then in a kind of almost in a cry of help, is it possible or advisable to make representations direct to Lady Hallett to express our concerns about the approach of the inquiry legal team? There's a kind of feeling there that this is getting so watered down that is the inquiry worth the time and effort it's going to take to do it? Can you give us a bit of reassurance on that, Peter Nelco?
Yeah, I mean, I'm raising these problems because I've promised to be transparent with everybody. And I think probably people are realizing I've got a bit of irritation here. I don't really understand why they're not being more collaborative with us. I mean, it might be that they're simply trying to sort themselves out, but I don't really think that's good enough. And absolutely, we will be making our feelings clear to Lady Hallett if we need to. Lady Hallett's approach on the consultation was pretty good in that, first of all, she went round, I think, 11 different venues, which was the right approach. And although you, the families, and the campaign basically arranged it all for her, she did rise to that. And also she did take notice of both what the consultation meetings, what she heard at them, and also what the kind of roundup written submissions we made at the end were, because her requests to change the terms of reference were, it was quite clear she'd taken account very much of what the families were saying. So it's not all bad news. But against that, we shouldn't just assume that Lady Hallett will be good or not good. I mean, we just need to realise that she is the chair, and we need to deal with her as the chair. We'll be polite and collaborative and take it forward. But if she does things or fails to do things that we don't think are right, then we will be pretty forthright about saying that. But there's obviously a balance, and we're at an early stage here, so we're not anxious to just fall out with anybody. So I'm just being honest with you about the problems we're having, and you can rest assured that we will not just be putting up with it. We will do what we can to move things along, and if we reach a point, which we may well do, where we have to go more directly to Lady Hallett, or indeed go public, as in have press conferences and things like that, then we will be doing that.
Right, okay, thank you for that. Okay, let's take a few more. We've only got a few minutes left, so let's go with a couple of more sort of out the ones. Ideally, in the opinion of the legal team, what sort of people should form the panel?
Well, we've argued very strongly that whether Lady Hallett is brilliant or terrible or somewhere in the middle, no one person can deal with an inquiry that really is as vast as this. And also that no one person will have the breadth of life experience that is needed to properly look at all of these events. And by life experience, you know, Lady Hallett is a retired, very senior judge, so she knows her own subject very well, but that is actually a pretty narrow part of life. And therefore she needs help from people who have lived their life in a different part of society, if you like. And also we need diversity. We need people from different heritage backgrounds. We need people from different socioeconomic backgrounds. We need balance. And so we need that kind of approach. What has come back at us is that the legislation refers to experts. So Lady Hallett should be supported by a panel of experts. We're far less keen on that because everybody has an opinion about COVID, and what we don't need is experts on a panel taking a one-eye-cooked earlier approach onto the decision-making part of the inquiry. There's a big role for experts. It's called witnesses. We should have experts. We should have experts that come along and give evidence which Lady Hallett and the panel can assess. But they shouldn't actually be on the panel, in our view, in this case. So that's what we've argued for. We've no idea, apart from the fact that Johnson has said he's going to appoint 2 panel members, with no idea what approach he's going to adopt or who they are. We're just waiting to find out. And we will go back. If we don't like them, we'll say it, and we'll go back and ask for more breadth, and we'll ask for more panel members. I don't think 2 is enough. But realistically, it's at the discretion of the minister. It's not even at Lady Hallett's gift. It's the minister.
Thanks, Pete. I don't know if you can answer this in 1 minute. I want to try and keep us to 6 o'clock. Are there any other avenues for establishing criminal liability, since the inquiry won't establish this? That's the last question for tonight.
Before we get to that, can I just do a flyer for a webinar which we've tentatively arranged for, I think, Tuesday the 26th July, to follow on from Lady Hallett's announcement on the 21st July. Yeah. So we'll have a sense by then of what she's saying, and we'll be able to discuss it. If there are no real issues raised by what she says, it will be quite a brief webinar, but I suspect people will have questions about it. So we wanted to have a chat with you as soon as possible afterwards. Yeah. We'll send out details.
And that's because because it's not a hearing, we can't raise things in front of Lady Hallett. So it's important that we deal with anything that arises from that. Sorry, the criminal liability. Well, very often an inquiry will raise the evidence, which will then lead to the police or another prosecuting body being able to then assess the evidence and take criminal proceedings against people. So the inquiry does play an important role in that. But the fact is that public inquiries, the statutory regime, does not allow them to determine criminal liability or indeed civil liability. But they can sometimes make determinations which won't leave much doubt about that.
Right. Thanks, Pete. Okay, that's great. It's 7 o'clock now, so I'm going to wind us up if that's okay. So as ever, I'd just like to thank all our panelists for their contributions tonight, and just give you all a quick reminder that a recording of tonight's session will be sent to all of our clients. If you did ask a question, you will get a personal answer. If your question was of general relevance, then it's going to be added to those lists on the Q's and A's. They're already available on the Brodie Jackson Cantor website. And after this, you will be sent one of our questionnaires when you leave the session. And we'd be really grateful if you can share your thoughts on tonight's session, be that the format or the subject matter or anything else. We're always looking to make these better. So thank you very much indeed, everybody. Don't forget, we will probably be doing another one. Look out for your emails on Thursday, the 26th of July. And if anybody would like legal representation, then again, Chris will just drop those details on finally at the end of the session. And if anyone wants that, then please do get in contact. So look, thanks very much, everybody. We'll shut the session now, and we'll look forward to seeing you all on the 26th of July. Thanks all. Bye.
Thank you.